Yes, so hello and welcome everyone to today's webinar on what you need to know about UK REACH. And as Mira just introduced me, my name is Elena and I'm a regulatory advisor here at GPC. So in today's webinar, we will be talking about quite a few topics. And the first one is background of UK REACH and some timeline basic principles. Then we're also going to discuss actors affected by UK REACH and which UK REACH procedure applies to your business. Also, we're going to mention more in detail doing and the registration under UK REACH and look into the registration fees at HCE for UK REACH registration and also some take-home messages. And finally, how we at GPC can help you to comply with UK REACH. So some background. On 1st of January 2021, at the end of the Brexit transition period, UK REACH came into force and EU REACH ceased to apply in Great Britain. And as a consequence, chemicals now may not be that are manufactured or imported in the UK now have to comply with UK REACH, and the EU REACH registration is not valid anymore. UK REACH applies in Great Britain, and that is England, Scotland, and Wales. And please note that even though Northern Ireland is a part of UK, the EU REACH still applies there, and it is provided as under the Northern Ireland Protocol agreed between EU and UK government. So no UK REACH for Northern Ireland. And also, UK REACH is based on the EU REACH regulation as amended by the REACH EU exit regulations from 2019. And UK REACH is described as mirroring the EU counterpart. And there's also some transitional provisions that you need to be aware of. These are important for importers and exporters who were accessing the GB market with an EU REACH registration prior to 1st of January 2021. And the purpose of these transitional provisions is to limit disruptions on the existing business. And the name of the transitional provisions are grandfathering and doing. And we're going to discuss in particular more about doing in a few slides. And transitional provisions do not apply to those who wish to place a substance on the UK market for the first time. In that case, you need to perform the full registration. So here's the timeline. And 31st of December 2020, it was the end of the Brexit transition period, and the EU REACH ceased to apply in GB. And still applies in Northern Ireland, and then UK REACH came into force 1st of January. 31st March 2021, it is the deadline for the so-called grandfathering. It is when GB-based holders of an EU REACH registration can basically perform a simplified procedure and continue to export, to use the British market. For 27th of October 2021, there's a deadline for doing submission, and this is for EU and EEA-based holders of an EU REACH registration. And deadline for full registration following doing and grandfathering is then 23rd, 25th, or 27th, and that depends on hazard profile and tonnage band. And this is going to be discussed more in a few slides. Some basic principles of UK REACH. The no data, no market principle. If you don't provide the data, you will not be able to access the UK market. The last resort principle in animal testing, access to information for workers, and the precaution principle. The competent authority is the Health and Safety Executive, HCE, and the compliance with UK REACH is to be carried out through the IT platform called Comply with UK REACH. Actors affected by UK REACH. So those who are concerned are manufacturers, both based in UK and non-UK based, importers, distributors, downstream users, and only representatives. When it comes to manufacturers, if you manufacture any substance in Great Britain, you must register it with HCE, and that is unless it falls under the transitional provisions such as grandfathering and doing. And the same is if you manufacture a substance outside of Great Britain and you want to place it on the GB market in a quantity above 1 tonne per year, then you also must register it with HCE. unless, again, you can perform doing on grandfathering. However, the registration will need to be held by a GB-based entity, which means that if you, for example, manufacture in Europe and you want to introduce it to the British market, you need to have a GB-based entity there who will perform the registration for you. And this can either be your GB-based importer or a GB-based owner representative. Regarding the importers, any substance imported to UK from the EU or EEA or from a third country in quantities exceeding 1 tonne per year must be registered with HCE. And GB-based persons and legal entities which bought chemicals from EU or EEA-based suppliers as part of their business activity before were considered as downstream users under EU REACH, but now they are considered as importers. And that means that as importers, you must hold the registration for UK REACH for the product that you import, unless the non-GB-based supplier manufacturer has appointed a GB-based OR that will do it for their substances. Downstream users. A downstream user is a person or a legal entity that directly handles chemical substances as part of their business activity in a professional or industrial situation, or comes into contact with chemical substances by producing mixtures, transferring substances between containers, producing components or finished goods, and it is neither a manufacturer nor the importer of the substances. Therefore, downstream user under UK REACH doesn't have a duty to register the chemical substances. However, as a downstream user, you must handle them in a safe way in accordance with the safety information passed down the supply chain. The role of an OR. So non-GB-based manufacturers, as I just said, who wish to place chemical substances on the GB market may appoint a GB-based only representative, the so-called OR. And an OR must be a natural or legal person established in Great Britain. As I just mentioned, for registration or performing doing the grandfathering, you have to have an entity in UK. And equipped with sufficient background in the practical handling of substances and the information related to them, appointed by a mutual agreement with the manufacturer, formulator, or article producer established outside Great Britain, and responsible for complying with the legal requirements for importers under UK REACH. Which UK REACH procedure applies to your business? So the most important question is your substance registered under EU REACH? If the answer is no, then you need to place the chemical substance on the GB market and perform the full registration because its substance is considered as new. If the answer is yes, and you are a GB-based entity that has EU REACH registration for the substance and been on there for 2 years in Great Britain, then you can do it through transferring it into UK REACH through the procedure called grandfathering. And if you are a EU-based or EEA-based entity, you must perform doing. And for both cases, after you've performed this small procedures, you afterwards need to perform the full registration within 2, 4, or 6 years, depending on hazard profile and tonnage found. So what is then doing under UK REACH? Downstream user import notification, that is what is called doing, is the process set out under the UK REACH transitional arrangements. And the notification allows EU and EEA-based holders of an EU REACH registration to maintain access to the GB while postponing their UK REACH registration deadline. And EU and EEA-based registration holders have then 2 options. They may either let their GB-based downstream user who is now importer to submit the doing to HC, or they may appoint an OR to submit the doing. And also doing must be submitted before October 27, 2021, so this year. And once they have been notified, the substances must be fully registered, as I just mentioned, within 2, 4, or 6 years. And we're gonna get into more detail in a few slides on how this works with the postponement. So what are the benefits of doing? It's mostly maintaining access to the GB market while securing time to complete full registration without extended stress, too much stress to register, and because you can have 2, 4, or 6 years to do that. However, there are some remarks, and first of all, doing is not a pre-registration because the concept doesn't exist under UK REACH, and doing is conditional upon the substance being already registered under EU REACH. So if you have a substance that is registered in EU REACH, you can perform doing. If not, then you cannot. And the doing needs to be done only once per legal entity, and it must cover all the substances that are dealing with it. So what are the conditions to perform doing? You either need to be a GB-based legal entity that is importing, so either you're the importer from EU or outside EU, or you can be a non-GB-based manufacturer wishing to appoint a GB-based OR to perform doing on behalf of the GB-based importer. And plus, the non-GB-based manufacturer, in that case, must also hold a valid EU REACH registration number. How to perform doing? So appoint a GB-based OR if you are not going to let your GB-based importer perform the doing. You need to open an account and HCE's IT system comply with UK REACH, and the doing number will then be assigned to you. And also that, as I mentioned several times, 27th of October, important deadline to perform doing. And past the deadline, substances will need to undergo full registration. So if you miss the deadline, if you could perform doing, but then you didn't perform doing and you missed the deadline, then you will have to undergo full registration from scratch, and you will not have this 2, 4, 6 years to do it because you will not have access to the UK market anymore. It will be considered as a new substance then. And how to perform doing? So second part is that doing takes the form of a standardized Excel spreadsheet where you need to include, for example, the doing number, legal entity name, and CAS number. And also that spreadsheet needs to be sent by email to a certain email address at HCE. And then for some additional information, you may add an attachment to the email. For example, this could be a safety data sheet. And then after this being confirmed by HCE that they received your doing, you can wait to perform your full registration depending on your tonnage band and toxicity. If it's a candidate list substance, sorry. So here is an approximate timeline to make it look a bit better. Deadline for doing submission is 27th again, 2021. I will say it many times today, so you will remember. And then in 2 years, in October 2023, there's a deadline for registration of those who have performed doing for those who import or produce more than 1,000 tons, more or equal to 1,000 tons per annum, or some chemical substances, or more or equal to 1 ton per annum of CMR substances, 100 tons per annum or more of very toxic to aquatic organism substances, and also more or equal to 1,000 ton per annum for candidate list substances. Then in 4 years, in October, 27th of October 2025, it's a deadline for registering those substances between 100 and 1,000 tons per annum, and candidate list substances that are more or equal to 100 tons per annum. And finally, in 6 years, deadline for registration for all substances between 1 to 100 tons per annum. And now about the registration under UK REACH. The registration process applies to non-GB-based manufacturers who wish to place a substance on the GB market for the first time, and then the registration should be carried out as soon as possible. And the answer to that, why it should be done as soon as possible, we will also discuss that in a few slides. And then GB-based importers or manufacturers who wish to place the substance on the GB market for the first time, same here, as soon as possible. and for GB-based importers and ORs who have previously submitted a doing. And here, again, this thing with 2, 4, or 6 years. And when the registration is done, you need to consider Article 26 inquiry and the registration itself. That's what the core is. However, there are some remarks. Registration is required prior to the manufacturer import into GB reaching 1 ton per year. So before you register, you cannot import or manufacture it, your substance. And registration is per substance, per legal entity. Registration is not required for mixtures, and registration must be accompanied by the appropriate registration fee. So what is Article 26 inquiry? The first step to new registration is the submission of inquiry dossier, and the process of for compiling inquiry dossier is analogous to the process under EU REACH, and the requirements are the same. And inquiry dossiers must be submitted to the agency via the comply with UK REACH. And upon receipt of inquiry number, your contact details will then be shared with existing registrants and grandfather registrants for you to be able to engage in the data sharing process. And then following the submission of an inquiry, comply with UK REACH, the IT platform will organize the registrants according to substance groups. And the substance groups will be made up of multiple businesses that can then submit a registration for the same substance together. And the group, in that case, must appoint a lead registrant to submit the joint registration dossier for that substance on behalf of all group members. And the lead registrant role should be claimed on comply with UK REACH once the dossier is ready to be submitted. And sharing the data needs to be to submit a joint registration with will be an important task for substance group. So if the substance group is in the process of forming, members must also find out what studies are available, assess any data gaps within the group, and consider other publicly available data. Here again, the principle of no data, no market. Should remember about that. So data is very important. And a legal agreement of a letter of access, and that can formalize the data sharing agreement and give co-registrants and new members access rights to the data to be used in the lead dossier for the purpose of completing the registration. And here we're going to talk about the fees. So UK REACH will apply fees to the same processes that were charged under EU REACH. However, the main difference will be that all the prices has been converted from euro to British pounds based on the average conversion rate for 2017. And an important thing here is how they categorize industries, enterprises, because that will depend on the price that you have to pay for the substance. And if you're a micro enterprise, then it means that you are less than 10 employees. Small enterprise is less than 50, and medium sized is less than 250. And everything above 250 is considered as a large enterprise. And then the turnover balance, you can also see to the right. And here are the fees then for the enterprises and the tonnage bands. And as you can see, the prices can be quite different, ranging from everything of £57 for micro enterprise that has a tonnage band of 1 ton per annum to up to 22,000 for a large enterprise with above 1,000 tons per annum. I can hold it a bit here so you can have a closer look. Okay, so and take-home message. Identify the substances to be placed in the GB market in a quantity that is more than 1 ton per annum, apart from your EU exports earlier. And then check if the substance is already registered in EU REACH, and EU registered substances then are eligible for doing, so you can perform that. And check if the substance will be placed in the GB market for the first time, then submit inquiry and registration dossier as soon as possible. And early submission means possibility to be a part of substance group. That's what I said, that's why it is important to do it as soon as possible. So you can prioritize substances for inquiry submission immediately after doing. And also check if the STS is updated or not. The substance classification should be as per the new GB-CLP. And identify the competent OR to take responsibilities towards your UK REACH compliances. Be transparent to your OR and give complete information to avoid any non-compliances. Again, no data, no market. And keep yourself updated on UK REACH developments. This you can do on our website, gpcgateway.com. And here again is the timeline. So remember, 31st of March 2021, deadline for grandfathering if you're a GB-based holder of an EU REACH registration. Deadline for submission of doing, 27th this year. And if you're a EU or EA-based holder of EU REACH registration, or a non-EU based also. And deadline for full registration following doing is then depending on your tonnage band and hazard profile. And finally, how can GPC help you? We can help you with your registrations and doing notifications. We can provide only representative services, study management of your substance. We issue safety data sheets. We can perform communication with authorities on your behalf, and we can be your compliance advisor regarding UK REACH. Thank you very much. I hope this was useful information for you.